agreement and plead, and so I want to put the paperwork together. So yes, sir. Could we have a reset?
Are you saying he wants to just do what, a time served, or does he want to do the PTI program, or what?
The PTI program.
PTI, okay. Can you take a look? Is he approved, or does he need a mitigation plan? Please. Horta is the last name.
Doesn't say Judge his driver's license and
No, I mean, is it above a 15 or is there an accident?
No, Judge, it's 0.109.
So he's not going to need a minute.
Accident, it was, driving facts was just speed.
So it looks like you're probably not going to need a mitigation package, just the application will be sufficient.
This would be probably just, approved by court chief as well.
Okay, you think so, or?
Yes.
Okay, an arraignment?
I do, Judge.
You ready?
Judge, it was, a roll from yesterday for some reason he was called back, Mr. Pollard, Pollard.
Oh, that's right, yeah.
I think we spoke to him, because he kind of.
Well, what I asked yesterday is whether bond petitions had been filed, and I didn't see them.
Okay. So,
That's why.
okay.
Oh, it was a trespass.
Yes.
I guess I assumed it was a DWI.
No, interesting.
No, he was a walkthrough. He received a PR on the court, and he didn't receive conditions to a pre-trial. I'm not sure if he ever got state conditions.
Oh,
House number because
Oh, yeah.
9 minutes.
262 301.
Yeah. So the conditions should have been, not to go back to it, this is the one where he allegedly goes to the city of Houston property and allegedly
Right.
takes something or other.
That's correct.
Right. So the conditions should have been, don't go back to this property, don't pick up any new cases, no contact with any of the complaining witnesses. I don't think they ever got filed. They never got done, and he never signed it. So that's what we
No
need to do. So what we'll do is he here now?
Oh, he's here.
Great. So we'll just have him sign it, and then he just goes to, so can you file, no going back to the location, no new cases, no contact with complaining witnesses? And then if I remember correctly, he didn't have a license either.
I'm not sure.
Do you mind running his driver's license? Because
He says he doesn't know.
does or does not?
Yes.
He does. All right. As long as he has insurance as well, then he can drive. But,
But he can hear you. Yes, he said yes.
okay, great. Yeah, so just want to file everything that, as soon as it comes up, we'll have him sign it and then he's free to go. And then it'll be waived for the next couple settings.
Perfect.
So,
Thank you, Judge.
okay, thanks, Marcos.
Thank you.
All right, Judge, the next arraignment is page 8. Cox, come on up.
All right. Good morning, Mr. Cox. Sir, you're charged with harassment. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay. Oh, it looks like you're also charged with possession of marijuana and a felony threat to disclose intimate visual material. Okay. It looks like all three out of the same transaction. So, all right.
Are we ready? Judge?
Yes, ma'am.
Officer met with the complainant, who stated she was in a previous relationship with defendant. She stated they broke up in April of 2026. Since ending the relationship, defendant has called or texted complainant every day after she repeatedly told him not to. The complainant provided calls, texts, social media, emails, Cash App, and other channels of communication where the defendant is trying to contact the complainant. The complainant provided evidence where the defendant threatened to post photos and personal info online, specifically videos of the complainant through Instagram, Craigslist, and OnlyFans. The complainant provided a fake Instagram account with a picture of her. The complainant stated the defendant was the only one who had that picture. The complainant provided text where the defendant stated, "Answer me or I'm posting it," and other similar threats. The defendant continued to threaten the complainant with texts like, You'll hate your life more and more every time you don't answer this phone. I know you work tomorrow. I'll be outside. You got till 5 to text me or I'm ruining everything. Your job, your car, whatever I can. This shit gonna get ugly. I'm gonna start killing people. While speaking with the defendant, deputies detected a distinct odor of marijuana emitting from his person. They confirmed he had active warrants and requested execution of them. Incident to his lawful arrest, they conducted a search of his person and located a package labeled strawberry milkshake containing a green leafy substance in his possession. It looks like he had a total of 0.09 ounces.
Was this when he was arrested then they were?
Yes, Judge, that's my understanding from what I'm reading here. As they were searching him incident to arrest.
So I see that he has prior criminal history and it looks like violent history. Is it the same complaining witnesses as well? And it's pretty recent, 2023.
It looks like the same complainant on the felony is pending.
Yeah.
And then not the same complainant for the past criminal mischief, Judge. And if there are any others out of county, I'm not sure if it's the same complainant or not.
Got it. Does he have any other criminal history that you see out of county?
No, Judge.
Mr. Cox, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to make sure that you're not using by testing you, and I will test you like crazy to make sure. You are also ordered to undergo and have a GPS monitor on you, and I'm placing a 1,000-foot radius that you're not to go within either of the complaining witnesses where they live or where they work. I'm going to protect my community at all costs. And if that means putting you in jail at a high bond, I will do it in a heartbeat. Do you understand me? You are not to be in possession of any weapons or go anywhere near these people. Use of third parties to attempt contact. You are not to have any direct, indirect contact. I'm telling you, you endanger my community in any way, it's going to go really badly for you. You understand me? You will be tested 40 days from today. If you test positive for alcohol or any illegal substances, including marijuana, I will revoke your bond. You currently have 3 open cases. You pick up a 4th, I will go bananas on all of your bonds. So do we know, did the felony court restrict internet access? They did not. All right. So at this point, we are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset. You'll meet with Veronica for your bond conditions. After that, we're going to reset your case. You will get the GPS monitor today. It is right. So link onto it so we know. It is your responsibility to charge it. It is your responsibility to maintain it. If I find that the battery goes dead, so will your bond. You understand? All right, come on.
All right, Judge, page 16. Winsler?
Good morning, ma'am. Ma'am, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay. Yeah, please.
On Tuesday, June 9th, 2026, Officer Smith was making a left turn in the 2900 block of West Bay Area Boulevard in Friendswood, Fergus County, Texas. While making the left turn, the officer observed a dark gray passenger car not displaying the front license plate stopped at the red light at the intersection. The vehicle was facing northbound. After making the left turn, the client made a U-turn and caught up to the vehicle at the intersection. The vehicle was in the inside lane and would stop past the designated stopping point at the intersection. The client ran the license plate displayed on the vehicle through NCIC to CIC, which returned to a gray 2017 Hyundai passenger car with an expired registration of June 2019. The client got behind the vehicle, and the vehicle made a left turn at the next intersection. They conducted a traffic stop. Upon making contact with the driver, there was a strong odor of an alcoholic beverage emitting from the vehicle. The driver's eyes were watery, and her speech was slow. She was identified by her Mississippi driver's license. The officer asked her where she was coming from. She advised her home in Lake City, and she was traveling to buy cigarettes at a gas station. She was asked to exit the vehicle. And she advised that she had approximately 3 vodka cranberries around 4:30 p.m. Her eyes were watery, her speech was slow. There was an odor of alcohol coming from her person and breath. Standard field sobriety tests were performed. She had a 4 out of 6 on the horizontal gaze nystagmus, 4 out of 8 on the walk and turn, and 2 out of 4 on the one-leg stand. Then the DIC was read to her, and her breath results came back at a 0.097 and a 0.111.
Ma'am, I'm going to find that there's probable cause to go forward with your case. Does she have a license to drive?
She does, Your Honor.
I mean, is it eligible? As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I want to randomly test you. If I find that you're using alcohol or illegal drugs, your bond will be revoked. You'll go into custody. Because this is a second offense, I'm now placing another restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. I send notice to DPS in Austin so that every police officer in the state knows if you're caught driving a vehicle and that vehicle doesn't have an interlock, they're going to take you to jail, and then you're in violation of these bond conditions. Do you understand?
Yes,
Ma'am, do you have the ability to hire a lawyer?
I do not.
How do you support yourself?
I work.
What do you do for a living?
I'm a field agent.
And what kind of income do you make on a monthly basis?
It's contract work, so it depends on the jobs available. No more than for $3,500 a month.
So tell me why you can't afford a lawyer.
I'm a full-time single parent. I take care of my kids. For the
So it's based on the poverty guidelines,
Yes,
right?
sir.
The federal poverty guidelines that you have to be making 15,800 and less a year.
Yes, sir.
I can have you fill out an application, but I need to know everything about you, whether you have any other household income, including boyfriend, girlfriend, spouse. And then I'll take a look to see whether you qualify. I need to know everything about you, what kind of car you drive, how many cars, stocks, bonds, mutual funds, and then I'll take a look to see whether you qualify. Deputy Williams will give you an application. I'm going to have you sign a receipt, and then we'll have you take your seat in the jury box, man.
Thank you.
Please.
All right, Judge.
Hold on. On the trial case,
Yes, Your Honor.
do we know it's,
I thought it dismissed on it this morning.
okay, so it's getting dismissed.
Yes, Your Honor.
Got it. Okay. All right. So yeah, just if it's being dismissed, just,
Yeah, and I let the defense know as well.
okay, great. Got it. Okay, Victoria.
Ready?
Yeah.
All right, Judge, page 20, Ramirez, come on up.
All right. Good morning, Mr. Ramirez.
Good morning, Your Honor.
Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you.
Okay.
On June 8, 2026, officer was dispatched to Harris County, Texas, roadway. Officer first contacted the defendant, who said he had been assaulted by his girlfriend, who he had been in a dating relationship with for a month. Defendant showed video of victim throwing coffee and kicking him. Defendant declined to pursue charges, and that he felt pain. Victim was visibly distraught and said that she wished to pursue charges and felt pain. Witness stated that he saw defendant bear hug victim, but saw nothing else. Defendant was arrested. Victim had visible injuries, including a red mark on her right shoulder, a red mark on her right side of the face, and a cut on her left forearm. Defendant had a bruise on his right arm.
So the allegation is that he threw, did you say coffee?
That she threw coffee at him while they were driving, while he was driving the car. He pulled over, they got into an argument, they're fighting, he's getting out of the car, asking him to get out, and the fight keeps on going. Defendant has sent us some videos of the altercation.
What did he do to her,
We,
if anything?
we threw her down to the ground and. held
Was
her
that in
down.
response to him, her throwing coffee to him?
Coffee and trying to kick him.
Is it hot coffee or is it cold coffee?
It looks like a cold coffee because it's in a clear plastic cup.
It says here intentionally and knowingly, recklessly causing bodily injury to the complaining witness by striking the complainant with the defendant's hand. Did you say that or no? Because I didn't hear that.
I did not. I did not.
Is that there or no?
On the videos that I saw.
No. Did you say that there? Yes or no? Is it in there?
Say that.
All right, I'm going to find no probable cause.
Thank you, Your Honor.
All right, Mr. Ramirez, good luck, man.
Thank you.
All right, Judge, next is page 23, Sosa. Come on up.
This also,
Sosa, correct. Come on up.
have an ear infection, you can't hit it. Oh,
Good thing you got 2 ears.
okay.
Where's it?
Come on.
Nice.
Mr. Sosa, you're charged with indecent exposure. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On June 8, 2026, at 5:39 p.m., officer was dispatched to a gas station on a report of suspicious activity. Defendant was inside the gas station. Defendant was insulting staff, exposing himself and masturbating. CW stated defendant exposed his penis and started grabbing it in a jerky motion. CW found this offensive and wanted to press charges. A strong odor of alcoholic beverage was emanating from defendant's person.
Do you have any other criminal history that you see? Mr. Sosa, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drug. You will be randomly tested. If I find that you're using alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand? You are not allowed to go back to this gas station. If I find that you go back, if you pick up a new case, then likewise into jail you go. No more PR bonds, like I said. Okay. Sir, do you have the ability to hire a lawyer?
Okay.
How do you support yourself? Are you working at this time?
I was laid off, November 24th. I've been trying to get back in since.
Hey, that's a long time. You still got to eat, bud.
Well, I'm a senior systems engineer, kind of getting older. Just the name of the game,
Sure, happens to all of us,
right? So we still actively,
but life doesn't stop. You still got to eat, you still need clothes, you need to get a job, right?
right?
So-
I mean, I go in slow, like, I was able to get the opportunity.
Okay, so Deputy Williams will give you an application. I need to know everything about you as far as how you're living, how you get money, how you eat, and then I'll take a look to see whether you qualify. I don't know who you have in this life, Mr. Sosa, but if you're a danger to my community and I have to put you in jail at a 10, 15, 20, $50,000 bond, if you don't have anyone to pony up that kind of money, you'll be stuck like Chuck with me for a long time. Do you understand? There are no mistakes in this life. There are choices, and you either make a good choice or you make a bad choice. You understand?
So, am I guilty?
I don't know.
Okay,
Presumably, you're not guilty at this moment.
I'm not guilty. Yeah.
Correct. But I'm putting bond conditions on you to ensure that you don't pick up any new cases.
Right.
We will give you a lawyer, assuming you qualify. We'll take a look at all the evidence. Then we'll put a plea bargain agreement on your case. You decide whether you want to take it. You don't have to take it. If you don't take it, at some point, we will set your case for trial, and then we'll have 6 people take a look to see whether the evidence matches up. The evidence will point to whose side is correct. I don't know. I wasn't there. There might be video, there may not be video. I don't know.
Right.
But the evidence will point to whose side is correct.
Okay.
That's just how it goes. Please.
All right, Judge, top of 25, Swede. Come on up.
Every time you violate conditions, the same thing will happen. If you violate conditions again, I'm going to triple, quadruple, perhaps quintuple the bond. You're at 10,000 now. It's only going to go way up. Do you understand, Mr. Swede? I'm not going to play this game with you again. The bond conditions will not change. They will remain the same. And if you want to continue to play the game, I'm going to be here for who knows how long, but really, do you understand? We are going to reset your case to give you time to hire a lawyer. I'm going to have you sign for all the conditions, and then we'll see you in 30 days. When you come back, please have a lawyer.
All right, Judge. Next is page 27, Walker Morris. This one's at CHA.
Okay. Hey, on Swede, GPS and a scram, please. And then curfew, the 9 p.m. to 6 a.m. What was your last name, ma'am?
Walker.
Walker. Ms. Walker, do you have a lawyer today? Tell me what you're doing about that.
I did, stuff in the mail, call and try to file as a
Okay, so your case is about 88 days old. I'm not giving you much time. You have 2 weeks. At that point, I'm fast tracking you to trial. Do you understand? There are a gajillion and one lawyers in Harris County. Some people just don't want to pay for a lawyer because they just don't want to pay for a lawyer. You don't qualify. So you need to hire a lawyer. 99% of them will put you on a payment plan if you ask. It's just a matter of you going out there and doing the grunt work to find one that fits like a shoe. You know, don't go to Gucci, don't go to Fendi, don't go to Louis Vuitton, you know, go to what you can do. Please.
I just wanted to make sure we start having the hearing later today.
I don't know. I haven't seen Kobe.
Okay.
And then is the defendant? Yeah, the defendant's here. So yeah. Yeah, I'm assuming. Anyone else?
That's it, Judge.
That's it. Okay. Mr. Lester.
Morning, Judge. How are you, sir?
Morning.
I am here today concerning the following case number, 2614 8440 1010.
2614.
Correct?
Yeah.
8440 1010. That would be Horta Quiroz.
Okay. Do you just want to reset?
Well, Your Honor, my client would like to enter into an agreement and plead, and so I want to put the paperwork together. So yes, sir. Could we have a reset?
Are you saying he wants to just do what, a time served, or does he want to do the PTI program or what?
The PTI program?
PTI, okay. Can you take a look? Is he approved or does he need a mitigation plan? Please. Horta is the last name.
Doesn't say Judge into first driver's license and the correct home.
No, I mean, does he need, is it above a 15 or is there an accident?
No, Judge, it's 0.109.
So he's not going to need a minute.
Accident, it was, driving fast was just speed.
So it looks like you're probably not going to need a mitigation package, just the application will be sufficient.
This would be probably just, approved by court chief as well.
Okay, you think so, or?
Yes.
Okay, they're going to approve it. So really all you need to do is the application. Once you do that, have them come in and we'll send them to go do a TRAS and then you're basically home stretch, you know?
Sounds like a winner.
July
I appreciate.
1st.
We're looking July 21st to the 23rd-ish for a reset.
Excuse me, Your Honor, that was July. Been having heck with technology today. This played havoc with me. For next week, July 21st.
Yeah, 23rd or 21st to the 23rd.
Any day there's going to work for me, Your Honor.
Okay, we'll put you on for the 23rd then.
Sorry, you blacked out, Judge. What day did you say?
23rd.
23rd?
Yes.
Okay, July 23rd. We'll get everything
Okay, man.
ready and be ready to go.
Have fun.
God bless you. You have a wonderful day.
You too. Take care. Hi, Stace. Come on up. Good morning. What's up?
I'm here, Miss Kimberly Sullivan.
So,
I don't know if the state is going to continue trying to correct this, but it's quite old.
yeah, it's time that we, put up.
Kimberly Sullivan.
Sullivan is last name.
Let's see that every possible point out, so I don't.
What? At 190 days? It's not even been attempted?
That's not good.
Okay, I'm going to set up her 10-day trial setting, really. If she's missing videos and there's no rip done, we'll give you guys 10 days. If everything's not in within 10 days, then. Yeah, all right, set it for a 10-day trial, or not trial, but a 10-day discovery hearing setting.
Okay.
Okay,
All right, thank you.
yes, ma'am.
Hey, Bertrand.
Sure,
Person Trent Morris.
okay,
Morris Estate got the ribbon this morning. I need to reset to do mitigation back here.
okay, we'll give you a week.
Can I get 2 weeks, Your Honor? He needs to just start the process today.
It's 190 days old, though.
Yes, Judge, and there's no surveillance. There's no way for the state to prove this.
But why are you coming to me at 190 days old and tell me there's no surveillance?
Prove their case, Your Honor.
No. If you're at 140 days and you're missing evidence, come to me and I'm going to put pressure on them to get their act together. And I'll give them a 10-day, discovery hearing setting. If they don't have it, then nothing comes in.
Yes, Your Honor.
You know what I mean? But you're coming to me at 190 days when really come a lot earlier next time. At this time, I'm ready to go to trial. So,
And we requested it every setting.
but if you don't tell me, I don't know.
I'll approach earlier.
Right. At 140 days, if you don't have, if you're missing, let me know and I'm going to put pressure on them.
Yes, Your Honor.
I just want to make sure that I heard the name correctly. Is it Trinity Forest?
Yes.
Yeah. So they're missing.
We're not missing anything.
Oh, you're not missing. You just told me that you were missing something.
Yes, we were missing the rest. There's no surveillance on the case at all because it didn't capture the incident. So we're
Okay.
waiting.
All right. I was under the impression that
Against the
when you
other.
say they don't have it, it's because they do have it. They just don't. Okay. So discovery's complete other than the rip.
It appears so.
Rick was done this morning, Your Honor.
So they got the rip.
This morning, yes, and that's why we want to do a mitigation package.
Okay. In 2 weeks, it's clear trial. I'm not giving you any more resets after that. All
I'll
right.
make sure it's submitted before then, Your Honor.
Got it. Don't submit the day before you come to court too.
I'll make sure our office submits at least a few days before.
All right. Next question. Ready?
I have I just got Harvey on the docket.
Hartley? Harvey.
Harvey, yeah.
Jail or bond?
Bond.
Okay.
The answer on felony court. Might be good today.
MIA? Okay. Let me see, what is it now? Oh, he's got an open felony warrant.
Yeah.
So, let me see, what's the bond? Yeah, okay, so, yeah, he's bond denied on the assault of a public servant. Okay, so I'll set it at 5,001. Okay. Thanks, bud. I'll reach out to you if he should come in. What's the problem?
He told me that I need him in my lap.
Hey, grab him.
Now he don't have. The license is all ridiculous. Wah.
I'm already very upset with you, Mr. Swede. You're on bond for a serious case and you're out there acting as if you're not on bond for anything, as if there's nothing going on in your life. And now on top of it, you're disrespecting our bailiffs. That's not cool. And if it happens again, I'm going to have a contempt hearing and you will be facing 180 days in jail. Do you understand? I will make a docket notation of everything that has transpired here, but everyone that comes into this place, you treat with respect, dignity, no matter who they are, no matter what gender they are, no matter their position. You understand? This isn't a place where you pick up people. If you want to do that, go to a club. This is not a club. Okay, please. Hey, if anything should happen again, just please let me know and we'll take the appropriate action. I've documented everything that's happened now and the multiple instances that he's been in the jury box acting up as well. So. Carlos, need to me?
Yes, you are.
What's up, buddy?
Good to meet you, Judge.
Hey, you too.
Well, I'm glad to be here. I'm sorry I wasn't here yesterday.
That's okay. I understand.
And we were almost in point. But they filed a different case and we're free.
Cool.
I did a lot of research on this case yesterday and I had a very good discussion with the chief. I presented her with some issues that I think the spouse was bad.
Okay.
I offered some, I told her I was bad case law. So we were going to respectfully ask for time so that the state could evaluate what we were talking.
What's the last name again?
Guananos.
It's an old case, right? I mean, I'll give like a day or two so that they can figure out, but I mean, it's over 200 and.
It's fine, Judge. I think within a couple.
Yeah, I mean.
If we get that case law from defense and also we'll be doing our own research, I've made some notes.
Yeah, let's put it on for Thursday. And then just see, our division chief should be here within hopefully sometime, but I get it. I mean.
Just a little detail, Judge. Thursday, I'm supposed to be in Brazos County. That's Friday.
Friday, it's on. There's no court Friday.
I know everybody's trying to avoid tomorrow because of the.
I'm okay with tomorrow. I mean, I'm
The world's
okay.
jumping off doesn't bother me. I think that's where.
Oh, is tomorrow World Cup day?
Yes, there is a game.
That's what all the other courts we had cleared their delegates.
Sure. Yeah, I get it. We're not doing tomorrow either.
Yes, sir.
Would Monday work, Judge?
Well, Your Honor, Thursday, I guess if you don't mind me appearing on Zoom.
Yeah, that's why we have it.
So we can see what the options.
Just have him prepared in the event that it goes south so that he knows.
Yes, Your Honor.
You know?
So I'm assuming Thursday, if the state agrees with us, then we'll, then of course, we may not have to worry about it.
Right.
If the state does not agree or they think there's a challenge, then I'll have a decision from Mr. Granados if we work out.
Come up, Granados.
Yeah.
But he speaks English, right?
Yes, he is.
Okay.
And we can have a decision whether or not we're going to work out the probation that the state is offering, or if we could set it for trial.
But I get it. I want you to understand something. I have enough drama in my life. I don't need any more. If you want to set this case for trial, I'm happy to set for trial for you, but I will not take any more plea bargain agreements after that day. Thursday is your last and final reset. We set cases for trial at 180 days. Your case is over that. So you need to meet with your lawyers, make a decision on what you want to do. If you want to take probation or if you want to take whatever they're offering, great. If you set it for trial, we will go to trial. I will not accept any more plea bargain agreements after that date. You understand? That is Thursday will be your plea bargain deadline. So we'll just have you sign a reset. Your lawyer, Carlos here, may be in another county, but I'm allowing him to appear via Zoom. In the event that we do a plea, just be ready to go through the paperwork so you know, be ready. That way we can do the plea, just get in and get out, and we can just have him sign everything, right?
Okay.
If you want to set it for trial, great, we just have him sign a reset, but after that time, there's just no more pleas. Okay?
Yes, sir.
Okay,
Thank
thanks.
you very much, Your Honor.
You got it.
Have a good day, sir.
You too.
This way.
Can I borrow you for one more thing? We have to do a cite and release, please. I have to give you a cause number and then we have to determine whether there's PC or not. It's 262-4691 on a Heinz. He's charged with driving on a suspended license. If you just want to read what happened, I'll find PC or no PC.
Officer observed the defendant operating his vehicle while using his cell phone and not hands-free. The insurance was also unconfirmed when running the license plate. Defendant's vehicle was a gray 2002 Dodge Ram. Officer activated the lights to conduct a traffic stop on the vehicle. Defendant exited the main lanes to service road. Officer then contacted the defendant, who's the driver of the vehicle and sole occupant, and asked the defendant for his driver's license. He provided the officer with his driver's license number. The officer ran his driver's license, and it was not eligible and currently suspended. Due to the defendant not having insurance, the driving while license invalid was enhanced. And
Okay,
that's all.
all right, I'll find PC exists. Thanks. We will issue a warrant.
Well, Your Honor.
Right,
Hey, George.
please.
Gregory on the dock.
Jail or bond?
Bond, he wasn't ordered to be here today. It's a non-file setting. I would like to be there on PC. On 4/18/2026 in Harris County, Texas, the officer responded to a terroristic threat call on CW advised that he had received threatening messages from a friend at school in which defendant advised that he wanted to take him out, referring to CW, and that, quote, "I wish I did." The table and took us pulled out. And that the defendant was trying to find where CW lived so he could take him out. If he couldn't do it at school, the defendant admitted he sent the messages to the friend.
So he sends text messages
Yes, sir.
to the friend. And what do the text messages say?
That he wanted to take him out, and I wish I did at the table and took us both out. And the other one said. And the other one just said, oh, and he said basically that he was looking for, that the CW was looking for the defendant's address. Defendant was looking for CW's address.
Are we supposed to assume that that's threatening? Maybe he wanted to take him out to dinner.
Furthermore, Judge, if I may, it says here in the divs, the victim explained to a fine on this date, a friend named John forwarded the threatening statements. These allegedly threatening statements weren't even sent to complaining witness, Your Honor. They were sent to somebody else.
She said something different. I don't know.
Well, that's what it says right here in the divs.
Is that right?
Right here.
I mean, it doesn't even matter. It really doesn't matter. Okay, I'll find new PC.
Thank you, Judge.
Yes, ma'am.
Maybe excuse.
Yes, sir. Counsel.
Yes, sir.
Hey, good morning. Okay, what is the last name again? Oh, he picked up a new felony case. Oh, no. So tell me, he's a violation of a protective order. Is this the same, in the felony case, is the same complaining witness as in this case?
No, Judge, they did,
So what happened in this new case, if you don't mind?
felony, on 2/17/2026, officer in his town places observed
Oh,
a motor vehicle traveling,
Reset. Oh, they're resetting the date.
traveling at a high
Hold on.
rate of speed. Past the officer, a traffic stop was conducted, driver's license check on defendant. Found an active, protective order with CW, the passenger of the motor vehicle. Defendant advised he knew there was a.
No, not in our case, in the felony case.
Yeah, this is.
This is the felony case?
Oh. Sorry.
Why she looks your night, so home affairs question. Accusing him of making public their public,
Accusing him what?
making public, transcending their named pictures.
So making public nude pictures.
Officer investigated an unlawful disclosure of internet visual material. Officers spoke to the principal who stated that there was a photo of a current student performing oral sex, which surfaced on Instagram page of the school on 4/10/2026. CW stated that she was advised by several students that an Instagram page, quote unquote, DIHS confessions, contained a post of a picture of CW having oral sex with defendant Chavez, her ex-boyfriend, while home alone with him, and he had recorded it. CW stated that around November 2025, they broke up. Defendant Chavez found out that she was friends with defendant JJ and sent him a copy of the video containing her and defendant JJ were in a relationship. CW stated that they made a police report of the incident, but did not have a case number, nor did they hear back from the police department they made the report with. CW stated that a picture from the video was posted on social media and she was told defendant and he was the one who uploaded the photo. CW stated that defendant JJ could have sent the photo. Defendant JJ gave a non-custodial interview where he stated that he was not aware of how defendant Aguilar received the video, and as he did not share it with them, defendant JJ stated.
I think we're good. Yeah, we're good. Mr. Chavez, I'm going to find that you violated the conditions of this court. You are a danger to my community. I'm now revoking your bond and you will go to jail. I'll set the bond at 10,001. Okay, you will go into custody now.
Thank you.
Thanks. Darla,
Yes, Judge.
hey, what's up?
So this is a follow-up on the PTI mitigation packet we submitted last week. I have not heard
Rangel.
back from the state. Oh, sorry. Yes, I'm sorry.
That's okay.
Approaching on Rangel.
Page 21. Yes, we have the application in the pacing packet. We just need to take a look at it.
Okay, so it should be here momentarily, right?
Or there's another sheet coming down. Is she, Trina's on bottom? I don't believe Courtroom is online, but Lindsay Pearson is supposed to come, by 11 o'clock today.
Yeah.
So let's do this. I'll set it for a day or two. Let's set it for Thursday, Darla, to see.
And I'll send it to Karina, so.
Yeah, and then we're just, you, as always, you can zoom in, but your case is 225 days old, so I'm not doing a long reset. So let's see what they say. If yes, then we can just have her come in Monday and do a TRAS.
I believe a TRAS has, no, it wasn't. We talked about that
Not
last
been
time.
done yet, so.
Okay. Yes, that's why she had to be there this time. So can my client's appearance be waived on Wednesday?
Yeah,
Judge, you said Wednesday or Thursday?
Thursday. Wednesday's a
sorry.
fee today.
Thursday.
Okay. Yeah.
Right. I will have been married 25 years on Thursday. Fun fact you probably don't want to know.
Wow. That's great.
Yeah.
Yeah. Okay,
Okay, so
we'll see
my
you then.
client's appearance can be waived on Thursday, and
Yeah.
if she's approved Monday, she can come in and
Yeah.
do her walkthrough.
Yeah.
Sounds good. Thank you.
Okay, thanks.
Not time for a case review.
Of course.
The first one is gonna be 2-5,
Okay,
2-2,
okay,
3-4.
okay.
So his probation is about to expire. He hasn't paid his court costs, that's the thing. So he has $4,778.
Yeah, but now, he has time to go to India and all this other places, and yet you just don't want to pay. No, it's your warrant.
Extension warrant? Okay,
No, it's your warrant. We've already, no.
okay.
I told him that I didn't want any issues, and there's an issue.
Okay.
It's your warrant.
And then the next one is 249,
Okay,
4967.
6-7,
249, 49670.
4967.
He's on that today. The last one is sober.
Yeah, okay.
He picked up a new car.
I don't know how to stand.
Where's Silvernail now?
I don't think it was brought, so we're rolling it for tomorrow.
I remember something.
It was 10 days ago. Yeah, when we amended his conditions and we picked up a new charge for violating non-protection board.
Okay, it is what it is. We'll get him when we see him. Hi, come on. Hi, yes, ma'am. Good morning.
And I am approaching on Miss Mesler. Lovella.
Okay,
Judge, Miss Mesler, bond condition says that she must have an interlock device. She told me that she does not have a car.
she picked up a DWI 7 days ago. So whatever car she was driving, that car needs an interlock.
Yes, Judge, she said she was using a friend's car. She drives her roommate's car every twice a month or so.
It still needs an interlock.
Okay. So
Anything she has access to that she's going to use or whatever, she needs an interlock on it. Doesn't matter.
would a portable device?
No, no.
Okay, so anytime she drives, then she. would-
Well, yeah,
Okay.
yeah, it needs an interlock.
Okay.
Sorry. Yes, ma'am.
Okay.
Hi, Ms. Pearson. Sorry, they've been waiting here a long time. So, you guys, if you want to come up, let's just make the announcements. And then, thank you for helping us out today. Guys, we are going on the record now. If you need to talk, please go outside. If you're going to use the phones, please go outside. Oh, well, we were. She should be out momentarily. Carrie, that's right. All right. Are you ready?
Yes, Judge.
All right. We're on the record in cause number 2611816. The state of Texas versus Kiwana Carey. Today's date is June 16th, 2026. It's approximately 11 in the morning. And guys, I'd like you to, with the state going first, please announce yourselves for purposes of the record.
Lindsay Pearson for the state. Carla Northby for the state.
And for the defense?
Kobe DeVos for Mr. Carey.
All right. We are here to have a probable cause hearing. We initially had one, I'd say, was it maybe like a week ago, would you say?
About a week ago.
And we decided to postpone it to have a full-blown hearing so that everybody could get into what they needed to do to ensure that there is probable cause to make a fair and full ruling. So I guess with that said, State, you want to go ahead and
Yes, Your Honor. So to just start by reading what the probable cause was. So on June 5th, 2026, officers were dispatched to an assault in progress, an unknown weapon check at a unit at an apartment complex in Harris County, Texas. The call slip had advised that the defendant was hitting a woman and was in the bathroom of the location. Officers had knocked on the door and a female opened the door and was visibly crying or was visibly distressed. She advised the defendant was in the bathroom. The female stated her and the defendant had a verbal altercation. Officer observed no visible injuries, but did observe her to be visibly distressed. Officer told defendant to come out of the bathroom and show him her hands. Officers unholstered a taser and pointed at the bathroom door, and defendant attempted to run past defendant. Officers attempted to detain defendant, but defendant continued to pull away from officers and placed both arms under his chest. Officers got control of the defendant and with assistance of another officer handcuffed defendant. So the officers were attempting to conduct an investigation into the assault and asked the defendant to come out, at which point he attempted to run out of the residence.
he's charged with terroristic threat though, correct?
Yes.
Did you say that there was a terroristic threat in that?
That is a,
That's the other case. The new
Yes.
case is an interference case.
Oh, I'm sorry. Okay, so, and I gave you the wrong cause number for purposes of the record, then the cause number is 2623705 for the interference. I'm sorry. So for purposes of the record, he was initially charged with a terroristic threat from March of 2026, March 23rd, 2026. And now on June 5th, he was subsequently arrested for interference with the duties of a public servant. The initial call that was placed to 911, did you say who made that call?
it was the female's child, Your Honor.
Okay, so a child.
Yes, who reported, and this is on the CAD, there was a assault in progress. Mom's boyfriend was attacking mom. There was an unknown weapon, or they didn't know if it was a weapon. The pulse of states there was a busted female lip, and there was threats to kill the female.
Okay. And so the interference that you're alleging arises when?
So officers arrive at the location and attempt to detain defendant. They are at the threshold of the residence, ask him to come out with his hands up. He comes up, they lower their weapons right when he puts his hands up and attempt to detain him to conduct an investigation into the assault, at which point he attempts to run out of the
Okay.
residence.
So that's what let's see what the information says real quick.
Just pulling his arms away is the matter means.
Right. Okay. So it says did then and there unlawfully with criminal negligence, namely pulling his arms away, interrupt, disrupt, impede, and interfere with M. Jones, a peace officer, while M. Jones was performing duty and exercising authority imposed and granted by law. Okay.
Yes, Your Honor. So when they were attempting to detain him and they had his arms, that's when he attempted to run out of the residence.
Okay. Is there anything else that you guys want to add? Anything else that you want to do, say, witnesses?
Yes, so when the officers arrived, the defendant had initially complied. He had his hands up, was putting them behind his back. And when officers started to attempt to detain him and put handcuffs on him, that's when he attempted to run out of the residence.
Okay. Anything else?
The only other thing I would add is in the offense report, it does say that he did pull his arms away from the officer when he was trying to detain him.
Okay.
A couple of things, an important distinction, because I think initially we heard he came out of the bathroom and attempted to run, and that's why the officers put hands on him. And then it was clarified that he was complying, and the officers put hands on him. And then I guess the representation is that he tried to run, and then there's a takedown. A few things.
Well, I think now you're saying as when he was being placed under arrest is when he's moving his arms away.
When he was being detained.
Okay.
And that's going to be a point of contention. I think their position is that this was a detention. Our position is that this was an arrest and there's no PC for the arrest. I'll kind of explain why that matters legally and what supports that. But importantly here, and I can call a witness, I can show the court the video, and I tend to do so just so the court knows what's going on. And I think that's part of why we're here, so you're
Sure.
actually see what happened. They arrive on the scene, and we don't contend that it's not okay for an officer to come investigate when they get a call from a child that says someone's being beat up. Clearly, they're allowed to be there. They're allowed to investigate. And they do some investigation. They come to the door, one cop. What we didn't hear from the Dems, we heard that a taser was pointed at my client. Initially, it's 2 firearms, which you'll see in the video. And then one of the officers says, I'm going less than lethal, and pulls out his taser. That's left out of the Dems, of course. But it's an important fact that goes to whether this is an arrest or a detention. But they call the lady out, the lady who had been the subject of this 911 call. They ask her, hey, what happened? Are you okay? What's going on? She said, everything's fine. And I don't want to misrepresent what says, but I got it for, she says, I'll just tell the court, nothing's going on. I'm totally fine. Everything's okay. My baby over-exaggerated himself. That's discussing the 11-year-old who called. So those are the 4 statements that they get out of the subject, this complaining witness initially. She tells the police that he's in there taking a shit. That's just the facts. That's what's told to him. The police then respond by saying, hey, the suspect's going to be locked in the bathroom. Well, that's the representation they make on their so there's, of course, no evidence at all at that point that he's locked in the bathroom or that he's barricading himself. They created that out of thin air. The complaining witness then responds, no, he's not. Meaning, one, he's not the suspect, and he's also not locked in the bathroom. This isn't a barricaded situation where you need to start justifying your use of force. The officers respond by telling the complaining witness, who they're there, I guess, to protect, get over there. Eventually, they put hands on her and actually sort of move her out of the way. They physically push her as she's trying to tell them, there's no reason to go in my house. Please don't create an issue where there's not one. They tell her, I'm not going to tell you again, get away from your own door. The Officer McDaniel pushes her out of the way, says, go over there. And he says, he's not using the bathroom. I know he's not. So now, of course, we don't believe the complainant. Stay back there. I'm not going to tell you again. Jones approaches the door. Breaks the threshold through into the house with his gun pointed. McDaniel has his gun out, and then he says, I'm going less than lethal. Then he pulls out his taser. Eventually what happens is they tell Mr. Carey, come on out. You're taking too long. What's taking so long? Come on out. This isn't a situation where they're saying, hey, Mr. Carey, you just need to come on out. We want to have a conversation with you. We need to ask you some questions. You're being detained. You're not under arrest. Like if this happened at my house, I think that's probably what would happen to me. Hey, Mr. DeBose, we just need to ask you a few questions. You're not being arrested. We see that all the time whenever there's a detention. And of course, what the law allows is a brief investigative detention to collect more facts. But what it doesn't allow here is an arrest, and that's what they went to. The reason we know, and the case law tells us what differentiates an arrest from a detention, the use of force. In this case, not only are 2 guns out and then a taser, but they go to physically put their hands on him and put him in handcuffs. By their own admission, what they're doing at that moment is putting him in handcuffs. They never tell him you're not being arrested. That's one of the factors. We often see that in these cases. You're not being arrested. I'm just handcuffing you for everyone's safety. You're not being arrested. That doesn't happen. In fact, much the opposite. Come out, show us your hands, turn around, put your hands behind your back. These are all the telltale signs of an arrest. I'll point out that the video is going to show that Officer Jones comes up to Officer McDaniel about 20 minutes into this and says, I just Mirandized him and got a statement. Well, we all know because he's been taken out to the car, they read him Miranda. The officer obviously thinks that he's in custody for the purposes of needing to read him Miranda, which goes to the idea that this was an arrest. I subpoenaed Officer Gonzalez here today. He recognized the subpoena, sent an email saying he could accept it by email. He's not shown up. But in his use of force report, in the offense report, if we're citing that, he says, I was there, I was assisting with the arrest. He uses the term arrest, and he's the 3rd officer who actually puts the handcuffs on. So from his point of view, it was an arrest. You're going to find from this video that the officers initially say, we're going to call the DA's office and try to get a resisting charge. Resisting what? Resisting arrest. Again, their subconscious judgment as experts that they're placing him under arrest. Now, the DA's office doesn't take resisting charges because this wasn't an arrest. Now they're taking a position that this was just detention. But this wasn't just detention. The amount of force used, the fact that they go hands-on with him, he's coming out saying, what did I do? What did I do? Well, if this were a detention to investigate, this would be the back and forth. But we just want to ask you a few questions. No, that didn't happen. What happened is they put hands on him, and then within about 3 or 4 seconds, he's taken to the ground. His face is busted open. He's seen by HFD because he's all beat up.